Everyone, we have a special guest today who may look familiar, especially to got quite a few regulars in the room, and so many of you have probably learned a few things from Brooke Smarsh before. I have, and it's actually great. This is the second one of this is the second guest speaker in like the past 3 weeks who I only got to know because they've been contributing so much to the community, and specifically to these calls. So Brooke actually, maybe the call after July 4th was just particularly helpful as she got into some of the legal questions around AI. And Brooke is an actual lawyer, so that helps. It's not just many marketers who are like relaying what they might have heard from their legal team or someone who sounds like a lawyer. And so Brooke, I want to really welcome you back, but welcome you officially as a guest speaker. For everyone else, if you have been, if you haven't, these are interactive conversations. So as there are things like this one, especially, I think will benefit a lot just from the questions of the community. When legal issues come up, we have a lot of great ones. So I'd love to hear what's on your mind. Brooke, Brooke is going to focus more on copyright specifically today, but Brooke, I'll hand over the mic to you to share where you do want to focus, maybe where you don't, and also the first most obvious question, I guess, for me and maybe for a lot of others here as you introduce yourself is what led you to take such an interest in AI, and like when did you even start doing so? So go for it.
Yeah, sure. Hello, everybody. Nice to see some of you and nice to meet some of you. I'm seeing some faces of some folks I used to work with too, so that's pretty cool. So I have been working with tech startups for quite a long time, for a large portion of my career, and you got to go where your clients are, and a lot of clients, as you might imagine, are in the AI space, whether using them or creating them. So started to get deeper and deeper. I am a solopreneur, but I do have a legal assistant that helps keep track of the AI updates because they are fast and furious coming at you. In fact, just got an alert shortly about US wanting to be at the forefront, obviously, and other countries trying to win the AI game. So yeah, so that's largely where I started to focus. I do have a presentation, so I will share my screen. David, does that work?
Yeah, you're a co-host now, so don't
Okay.
worry about like letting people in and stuff. You can focus on your talk, but
Okay.
yeah.
Great. And to David's point, this can be very interactive. Happy to take questions along the way. Happy to wait till the end, but feel free. I don't know that I can see everybody, so just start shouting out questions if you so desire. So, and to David's point, I'm focusing on AI. When I would go to these startups, I would do this type of a presentation mainly for the marketing team, to get a sense of copyright, trademark right, privacy, that type of thing. Not to be experts in it, but just to know when to ask questions. And obviously now this has AI weaved all throughout. So just to get started, let's take a 20,000 foot view of ownership and property generally. So you think of property as two main categories: real property and intellectual property. And one thing to understand is property ownership doesn't exist without a law telling you that it exists. So it is a legal construct. Welcome to my world, everybody. So, you know, intellectual property, you think of patents, trademarks, copyrights. And what we're thinking about, and I'll get into some of this for copyright specifically, but you've got covered the use by the owner, what the owner can do with it, and what others can do with it. So we'll go through some of that. So copyright protects original works. You've got computer code, audio recordings, video, photography, artwork, books, blogs, blah, blah, blah. It is a federal law, and this, I'm contrasting this with, a lot of you might be familiar with privacy, and it's a patchwork across states, but we'll also get into the right of your own image and likeness, which is also a patchwork. It's for, in case there's trivia, US Code Title 17. But the Copyright Office is the one that governs it. So what we'll look at first is when you're creating the content. So it is owned by the person who puts pen to paper, fingers to keyboards, unless there is an employment agreement or some other contract in place that shifts the ownership to the non-creator. So when you started at your company, you may have signed an offer letter or some sort of paperwork that specifically says anything that you create while you're working for us is ours. Or if you're a freelancer, you've signed a contract that says anything that you create under this contract is mine. If you're the one generating the contract and hiring the freelancer or the employees, you will want to make sure that you get that paperwork in place before pen to paper. You can shift the rights across, but it's just cleaner and easier if you do it in advance. And then you don't need to register copyrights, but and the protection comes immediately if the work is original and if the author is human. And I'll get into both of those. Registration is just helpful when you want to protect it, put people on notice, and you get additional damages if it gets infringed. So copyright is created if the work is original. So it can't just be a replica of something that's already been created. It can be a derivative work. So if you think about, this movie is adapted by this book. So the book is the original, the movie is the derivative. Or when you were in school and you had to keep buying new editions of your textbooks, those are all new derivative works. Or even translations of a book from, say, US to, or English to, say, Japanese. The translation is a derivative work. So it must incorporate some or all of the pre-existing work, but add some additional original copyright authorship. So that's if the work is original, and then if the author is a human, which might seem obvious, but obviously AI muddies the waters. There were actually people who tried to register works that they claimed the author was the divine, and so the Copyright Office said, "Sorry, that's not a human. No copyright in works by the divine." So, all right. So here's an example. So you've got this web page, and let's say you want to have a copyright, and you're looking at the color, the logos, the work, the article, the picture, and even the template, the web template. So some of this may be original to you, but some of it you may license. And so that's where you've got a mishmash of what is yours. So it has to be original to you. So say the article, and what is somebody else's. So say the template or the photograph. Any questions so far? Pretty basic stuff. All right, so it has to be human. Some of you may remember this, where we had this macaque who took a selfie. The photographer set up the camera, walked away. A very curious animal came over, hit the button, got a selfie. And the photographer tried to get the copyright in the picture. He said, "Hey, look, I've set up the means for this to have occurred," but the Copyright Office said, no. In the meantime, PETA decided to get some publicity out of this, took on the animal as their client, tried to get a copyright for him, and the Copyright Office said, sorry, again, needs to be a human, so no copyright existed. Now we get to AI. So the Copyright Office came out with some guidance back in March of last year and started with the analysis of, is this actually a human? So whether the work is basically one of human authorship, with the computer merely being an assisting instrument, or whether the traditional elements of authorship in the work were actually conceived and executed not by man, but by machine. So there is a line. And they went on to say, if you're just using AI prompts, you're not the owner, because the users don't exercise the ultimate creative control over how that AI interprets the prompts and generates the material. So they likened it to hiring an artist, commissioning an artist and saying, hey, I have this vision, and the artist creates your vision, but the artist is the author. So here the machine is the author. Where you modify the output, you can get the modifications that you created if it's independent of and is essentially more, your human creation. Those modifications can get protection or can be registered, but not the AI, untouched AI. Any questions on that? we'll get to
I
some decisions and some additional guidance on the next slide, but any questions at the moment?
I mean, I'll ask one of just the most just basic things that because like with like photoshopping, right? Like I guess like because like as long as like if the photoshopping's done by a human, that's one thing. What if there's like an like auto, you know,
Yep.
uh,
Yeah, it's a great question. And actually, we do get a little bit into Photoshop, but essentially, I would think of the determination. So it's always a fact-based analysis.
mhm,
Every time somebody tries to register, it's not easy stuff. And I would consider that the line between human and non-human is not a straight line,
mhm.
but instead think of it as a winding river that's trying to cut swaths around. It's just not always clear cut. And, you know, a little bit of spoiler alert at the end, I'll get to some of the things that are happening. And the Copyright Office is asking for input as to whether the line is in the right place at the moment. So we will address some of that. All right. So some of the guidance and some decisions.
Brooke, can I
Yeah,
ask a quick question, please?
of course.
If you're using the prompt and it gives you something back, and then you're continuing to use the prompt to enhance or change or direct it,
Yep.
that's not considered like human input at that point.
It's not. It's
But
not. And go
if you
ahead.
took like written copy, let's just take as an example, and brought
Uh-huh.
it out of that, put that in a word processor and Word, and you're like, editing it there, and then dropped it back in for additional feedback or thought, is that human input then at that point?
Yeah, that's a great question. I think that's it's hard to answer on that front. I don't know that they've given guidance specifically on that analysis. You do make a nice segue though into the first bullet on the next slide, which may help. So, Zara of the Dawn was a graphic novel from 2003 where the woman who created it wrote the entire text and did over, and I can't remember if it was 400 prompts or 600 prompts to create. She took a year to create this book using AI and kept rejiggering using prompts. And the Copyright Office said no protection for the photos, not for the artwork. Yes for the text, yes for that, but not for the design, the images. And I personally think they got that wrong. And I do think that as they're looking at where does that line go, I think they may start to change their mind about whether the prompt is a tool or creating the work specifically and using the creativity. So that one was a I think a lot of us were pretty surprised and displeased with that answer. But that's what we have right now. So a couple of other examples that they gave. So let's say you are doing a man on the street, you've got your camera outside, you capture some images in the back, like the Apple stores, the Apple logo, the McDonald's, people walking by, license plates. So you've created the video, you use AI to blur that stuff. That there is no issue there. That is using AI as a tool. That is still your creative work. No issue with creating with registration and getting copyright protection. So let's say you're doing a shoot and you've got an action and some mud gets splattered on the actor. You don't stop, you keep doing it, you don't see it until post. You go to fix it in post using AI, no problem. However, if instead you go and you use some special effects to create that mud, to put the mud on different places, that the special effects, if generated solely by AI, is not protected. We talked a little bit before about the foreign language. So when you translate something into a different language, there are decisions to be made around the prose that have an impact on the creativity of the work. So if you solely use AI to generate a foreign language translation, not protected. Use a human, protected. Fixing an old music recording, again, using the tools to go from mono to stereo or getting rid of some background noise, that's not enough to change the creativity that the humans created. So no issue there. And so what they basically said was, if you're using Photoshop or other tools to modify, to enhance, to bring out your vision but it remains your vision. That's not a problem. But where does the creative control lie? Is it with the human, or did the creation come from the AI? So I don't see your name, but the question that you asked, I think, is a really good one. What do you do if you've changed it and then you have AI enhance it? Where is that line? And I just don't know that we have an answer yet. And that's one of the things that they're working on. Any questions here? I'm going to stop for a sec and see if anybody's got any questions. No. Okay.
Maybe a high level question we might get
Sure.
to later, but what is the process of this copywriting in general? I mean, is there a state of the art? There's simple ways to do it through, you know, mailing stuff to a copyright office, all this kind of stuff. I'm not sure. If that's
Oh,
part of it.
sure. Yeah. So just very, very briefly, I mean, literally the moment you've created it, you've got protection. You do not have to register. But the Copyright Office has a registration process. It's a form you fill out. There's actually lots of videos that can help you with what do you put in author? Don't put the divine. That's not helpful. What do you disclaim as third party? So it's an entire form that you would fill out. So the Copyright Office has lots of stuff, and I'd be happy to kind of talk you through that. But yeah. All right. So we talked a little bit about copyrighted material. You've now owned something. There are two ways for someone to get the right to use copyrighted materials. The first everybody understands is permission being licenses. So you've got your multiple music licenses. We talked about the templates. You've got photos where you can get from maybe a Getty or a Creative Commons, EULAs and user license agreements for software. So there's plenty of ways to get licenses. And then you've got fair use. And so what the Copyright Office, what Congress did when it wrote the Copyright Act is it tried to give the protections to the owners who created the copyright in the first place, the original works, but also to continue to allow for and encourage creativity and innovation. So you don't want somebody to create something and then foreclose the ability to build upon it. So that's what's behind fair use. And to know whether fair use is legitimate, it's a 4-part test. What is the purpose and character of this new use? How creative was the underlying copyrighted work? What amount of that work was used, and what was the effect on the market for the copyright owner, the original owner? And just to tell you, this is really, really hard. It may look simple as words on the paper, but practitioners who do this day in and day out may disagree on the same set of facts. The Copyright Office may have differing opinions. Courts will have differing opinions. So this really is pretty challenging stuff.
Yeah, and I mean, it's also really interesting because like we just had a demo this month from a company, Augie Studio, for instance, and they actually license Getty Images videos where you can either use your own script or have AI generate a script, have an AI generate voice or your own, and then stitch together a montage of videos based on that script, which again may or may not have been human originated. And you can include clips that it finds from your own content library. I could stitch together scenes from different AI Insiders calls, or it could be a voiceover about AI Insiders, but using Getty Images clips, right? And so I mean, it sounds like, if I'm hearing you correctly, then if someone tries to have copyright protection for one of the videos they create through a tool like this, that it really varies, even like not based on what the tool could do, but like how much human intervention there is, and is it really like, but if I just use an AI script and stitch together Getty Images, that's probably not enough. Is that right?
Yeah, I think so. Yeah. Yep. Okay, so this just goes through a little bit more. So the purpose and character of the use. Is the use transformative? Is it commercial in nature? Does it change the underlying work to something new? Or is it commenting on the content of work? Or is it just bad faith that you're taking this? You didn't want to pay for it. The creativity, that is a continuum. So the more creative the underlying work, the more protection it gets. Amount used, you've got the percentage or heart of the work. Now, I have heard from some of my clients that, oh, well, I just used 4 bars, and so that's fine. I've heard a rule that there's a bright line of 4 bars or less for music, we're fine. That's not legit. That's not true. Because for those of you who are of a certain age or like to watch older movies, you probably recognize do do do, right? And so that's the heart of the work. You know that that's Jaws. You're about to be eaten, or somebody's about to be eaten, and that's the heart of the work. I had somebody come to me with a video. There was an actress who got maimed. She was coming out of the hospital. Somebody got video of this. It was a 3-minute clip. Somebody licensed it, paid a ton of money. They wanted to do a screenshot, but it's only a screenshot, but it's what she looks like. That's the heart of the work. And then the effect on the market. So in the screenshot, clearly nobody's going to pay to see the actress if you can see it for free on a website. So that's just some quick examples. So this is the latest Supreme Court case. It was the Andy Warhol Foundation versus Lynn Goldsmith. Lynn Goldsmith was the photographer. She did the picture on the right, and Andy Warhol created the image on the left that got licensed to Vogue magazine. The reason I'm bringing this case up is because, as I was mentioning, there's a river that's meandering between, not just original or ownership by a human or not human, but also between fair use and not fair use. What's the protecting of the underlying owner of copyrighted work versus continuing the creativity and innovation? There is definitely a push-pull here, and this case helped bring it back to protecting the underlying work. For a real long time, there was a case a couple of years ago that gave the creativity of future use more leeway to use these underlying copyrighted materials, and now this Andy Warhol Foundation case brought it back, which at the time of LLMs taking all of this original content and learning on it is an interesting time. So this case was from May 2023. Goldsmith licensed that photo to a photo to Vanity Fair many years ago. They didn't come back to her. They instead licensed from the Andy Warhol, and she said, "Look, you're harming my market. I could have licensed it to Vanity Fair." So the facts aren't great here for us, for those of us who want to use underlying work, but it is what it is. And then some other examples, when you're taking a recipe from a recipe site, actually that was a perfect, David, for you to mention recipes. Is that being taken? And so are you now stopping people from going to the blogger? Is the blogger losing money because those recipes are found elsewhere? Weird Al parroting. It's not really a parody. What Weird Al does, he changes the lyrics, so he has to get a license for the underlying music. And for those marketers on here, generally speaking, fair use is just not there for you. You're not going to create anything particularly creative and unique that helps with creativity because it's commercial to help market your brands. So generally speaking, you're not going to win a fair use argument. All right, so now with this LLM training, let's look at the two different licensing versus fair use. So we've seen a ton of licensing in the media. You've got Reddit and Google. OpenAI is spending a ton of their money, Meta and Shutterstock. But these are companies that have a ton of money to spend. But if you've got an AI company and you've got some investors and you don't even have necessarily a proof of concept, but you need this copyrighted material for your LLM training to even see if you've got a viable product, you can't really go out and spend all of your money on licensing. So you want to rely on fair use, and you do this analysis. Well, I think it's tough, right? And again, it's fact specific. So let's look at the purpose and character of the use. Well, are you looking at the output or the input? So if you're taking, say, all of the music library of the labels and you're creating a training mechanism for a completely new technology, well, that seems to be pretty transformative. But if you are recreating, New York Times articles from your input, maybe not so creative. The creativity of the copyrighted work, again, that's a continuum. So how creative is a news article that describes a scene right in front of you versus, and my apologies to any journalists, because I know what you do can be quite creative, to music, people who are creating music, very, 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 very creative. An amount used obviously is 100%. And then the question is, what's the effect on the market? So the New York Times argument may be, now people don't need to pay for our articles, so you're killing us over here, versus the RIAA that says, well, I want people to pay for my Elvis Presley. So it's very different. But what the RIAA, just as an aside, is really saying is if all these musicians are creating music that doesn't need a license for Spotify to then stream, I ain't got nothing in the future to sell to Spotify, and there goes my business. So it's the record industry again worrying about new tech. But what you also have is, again, the US wants to lead in disruptive technology. And you can't tamp down, I don't think the courts are going to come out on tamping down an industry so early in the game. Any questions? Okay.
What advice do you have kind of in general? Is just to cover your ass, like you're saying, or is it, get lawyering up?
I'll get to that. I'll
Okay.
get to that. Yeah, I have some ideas, but let's hold on that one. Actually, we're almost here. So if you're the IP owner and you want to use AI, but you don't, potentially, that the tool will also train on your IP. So what do you want to do? So you're thinking about, is it confidential? So is it the code that you're writing for your product that you don't want people to have your source code, so it's highly confidential. There's something called naked licensing where you give your IP without brand guidelines or keeping an eye on it. So you ultimately devalue your own IP. Or maybe you look at paying for the versions that state that they're not going to train on your data. So when you're looking at this, I like to use a risk calculation approach where it's the likelihood an event occurring times the magnitude of the harm. So if the magnitude of the harm could be somebody recreating all of your source code, that's a high. So the harm would be all the way over the high column. But what's the likelihood? You've got to be honest, try to be honest with yourself to the extent that you can, your crystal ball isn't too blurry. Where does it fall? And so for each of these decisions, and particularly if you're part of a larger company where you have a legal team and you have a business team to discuss these things with, I think that they would probably do a very similar calculation. And maybe the lawyers, stupid lawyers are going to overvalue. The risk is super high. The likelihood is super high. And you're like, no, it's not. So I know a lot of my clients are like, it's never going to happen. The risk is almost zero. So I think it's somewhere in the middle, and maybe y'all can negotiate as to which box this falls on. And similarly, if you have an AI company, I think you have to do a calculation of money spent versus holding on until these cases come out, and again, there is something that the Copyright Office is looking at, so we can get to that. Any questions on this?
Yes, I have a question.
Yep.
So if you're a brand and you're not building AI tools, but you're using AI solutions, it seems like this is what's the calculation? Because like working with certain clients, we don't build AI tools.
Yep.
But they don't want to use anything that's been created by AI, whether it's an image, text, or because they're worried about copyright.
Yep. So I will get to that in a second. This is using AI yourself and putting your own, let's say you want AI to help you fix your code, right? And so you have to upload your code to get it to fix it, but then it may train on your code. So this is for you as a copyright owner giving it to an AI system, and that they may train on. So this is some of the risks of that. But as far as the output, we will get to that next. So here we are. So how important is the ownership of that output? Because remember, there is a chance you don't own it. So when you have AI writing your code or creating your trademark or creating your taglines, what is the company value on that ownership? So if it is the code and you have investors trying to value your company and you're a tech company and the code is super important, you may want to really think about, because they are asking, investors are now asking, are you using AI to write your code? Or what's the post-creation market? Right. So again, talking about the music industry, if you can't own and you thus can't license and get money from licensing what you've created with AI, then you've got to weigh that risk. Or copycats. So what would the impact be on your company if your competitor can use the same tagline because your tagline was created by AI and you can't protect it? So that's on the ownership risk. But then on the infringement risk, what happens if you've used AI and what it spits out infringes on somebody else's IP? So there's been a lot of work that these AI companies are doing to include indemnifications in their terms and conditions. So there is some protection there. However, that protection doesn't help you when you get a cease and desist. And you have created an entire marketing campaign, an entire brand that you've been out there for 6 months. You've changed your company name, you've changed the logo, the look and feel, you're out there and you get a cease and desist. Well, now you got to tear it all down and start over. So there's the time and the effort. So that all goes into that same calculation, right? And again, I'm not saying not to use AI, because you may say, well, here's what I'm doing. It's a low risk. And if something happens, it's a low harm. It's a green. Don't care. It's all good. And so that's the evaluation and the calculation, kind of a continuum of when do you use AI and when do you not use AI? Does that help with that question?
Yes, it does. Thank you very much.
Yeah, absolutely. Any other questions on this so far? All right. So that's the copyright piece. I'm going to touch ever so slightly on right to publicity. So people have the right to decide how their image, likeness, and voice are used to protect their reputation. This is, as I mentioned earlier, protected by state laws. You've got a patchwork of states that have different opinions. And the most protective, as you might imagine, California, because of the industry out there. And then Nevada, when they say what happens in Vegas stays in Vegas, that's kind of true from the law. So funny story, I used to work with the Howard Stern show, and they did some video from Vegas with the big adult film convention there, and they came back with all of this B-roll, and I'm like, you have to blur the faces. What happens when that wife thinks that her husband's in Tampa Bay and there he is at an adult film convention? So you want to be careful, because anyway. And then the one on top, although that's a spa, I did have a situation where my team pulled stock footage that had a person in it and wanted to use it with a article that they were writing about STDs, and I'm like, you're implying that person has an STD and they may see it. So you want to be really careful about how it. Yep.
Well, one question is because of what happened, or maybe didn't happen with one of our favorite celebs, Scarlett Johansson, and
yes. So I'm actually getting to that.
Oh, great.
Yep. Yep.
And I'll ask the question that relates to it, so maybe you could cover it together though.
Yep.
And that's like if I go and find a like Robert De Niro sounding voice, right? Like on 11 Labs or something like that most people will think is De Niro, but isn't, right?
Yep.
Then like, is that okay or not?
Nope. It's not. It's not. Most likely not. So here you have Kim Kardashian, and I had to have my intern tell me that was Kim Kardashian. But anyway, Kim Kardashian in an Old Navy commercial for the Super Bowl, she sued them and they settled. I had a commercial come to me from WWE using a Tiger Woods lookalike, wearing the red shirt and the black pants, doing his signature moves. So it did look like that person. With the Scarlett Johansson one, I think, and again, we'll get to this in a second where we're going, but it needs to be, I think, more than just sounds like, but has some of the similar mannerisms, and so is trying to copy, right? So again, you've got people who do impressions. You can't just do impressions of people, use them in a commercial and be safe, because people do have the right to their own image, likeness, and voice. And so that gets to AI, where, let's go back to that stock footage example. So you're like, hey, I'm going to use AI to generate a person, and it's getting pretty good. It looks like a real person. And it's not a real person. So I'm in the clear to use it with this article on STDs. And oh my God, I see it and it looks just like me. Holy crap. My mother is calling me thinking I have an STD and did a commercial, right? And so it's just random. It just so, but there's billions of people in this world, and there is a risk there that you're going to run into trouble. So David, does that answer your question?
Yeah, and
Yeah.
I guess it does in the sense that like say my next door neighbor, he just happens to sound a lot like Robert De Niro, but then like you can't do the De Niro shtick and like in a way that expects me to get away with it. But if it's like just like sounds like him and it's just like an Italian New York accent, like okay, well there are millions of people who have a voice like that. Maybe some who sound kind of close, right? Like
yeah. So it really does come down to, at the moment, state law and case law, right? And what's in your files. So when you wrote it, did you say would love to get De Niro for this? Right? Do you have anything in writing, or is it just happenstance? The person sounds like De Niro. So it's again all fact-based and really freaking expensive, which is why all this stuff largely gets settled out of court. So you may have some case law, you may not have all case law, but if your company is based in California, I would avoid it.
So, and you should probably take the line, "Are you talking to me?" out of your script.
Yeah, exactly. All right, so here's my crystal ball. So we kind of have a sense of where we are, but that's not very helpful with this nascent technology. So back in October 2023, the Copyright Office issued a notice of inquiry and solicited comments from the general public. They got over 10,000 comments, and they were asking about these 4 topics. What should be the use of copyright works to train AI? Should it be infringement or not? Where should that line be? And then what remuneration systems could be possible? Give us some ideas that maybe we can help solve this problem. So we haven't heard back on that yet, but that's one. The next was, what about things that are generated by AI? Is that Zara case or decision, the one with the graphic novel, is that wrong? And should that line between human and non-human be moved given this new technology? And then what is the potential liability for infringing works generated from AI? And isn't it great that these companies have these indemnification clauses, but if you're a company that has, $200,000 in the bank, maybe that indemnity clause isn't going to be very helpful because they can't pay out on it. And who's to be responsible? Is it the user, the prompter, or the AI company? And then this gets back to the identity and style of human artists, exactly what you were talking about, David. They are soliciting comments on what about these personal attributes. And in this last bullet, again, the Copyright Office does not have jurisdiction over this. And so they may try to come up with a rule around it, and it will immediately get challenged in court and be struck down. But what will be helpful is, again, I don't think a patchwork across the states is going to be helpful on this. We need Congress to act. God help us all. But if Congress can be given this information to help them draft rules and laws that are helpful. The White House also issued an executive order back in October 2023 for agencies to look into AI, to study it, issue reports. The first report came out a few weeks ago, I think in July. It focused on cybersecurity. That is the #1 issue right now because this technology is getting in the hands of bad actors, and how we used to track who we thought were making nuclear weapons was made harder unfortunately, by AI. And so they're coming up with new whack-a-mole ways to figure out who might be making nuclear weapons. That doesn't keep people up at night. But both the executive order, you've probably heard about the EU AI Act, those focus more on the AI systems and less on the use of AI because they're looking for responsible actors when harnessing this technology. And that's it. That is a presentation. So any questions?
I have so many questions. But first of all, thank you. That was amazing, and I learned a lot. And the context is so important with all of
Yeah.
this to get down how this is built. So quick background. I've been building in this space for a while on trying to figure this kind of stuff out on an authorized level on blockchain.
Uh-huh.
So what I was building two years ago that got put on hold was authorized AI, and that was about trying to empower at that point the AI libraries to create their own neural networks that sit there. So it may be a neural network, you don't know what's going to come out of there, but at least the neural network is all owned by one entity. So whatever comes out of it, you can source back to. And this was before the Supreme Court thing, but still, the point is we want to make on-chain outputs from AI that have provenance built into where they come from. That may change in terms of like what the copyright is of how much you own or whatever, but at least you're sourcing and then building on top of. The question I've always had around this is, and it's still very opinionated. If you are making an object that is an NFT, but it's the source, the media is AI generated, but there's still value in it because it came from, it's signed off by, it's approved by, it has a chance for you to then do other things with it once it's made. It can build its own provenance from there, et cetera. There's still value in it. And there's still
Sure.
the chance of like, if it's music, playing it on chain, a blockchain player, et cetera. How does that work in terms of the value of the thing? Is it, how much value can be added to something that's AI generated when you're building things around it on top of it? If you know what I mean.
Yeah, I mean, great question. It really, there is value in things outside of the copyright ownership, right? And so it depends on what the market wants to pay for it. It doesn't necessarily have to be an IP license that you're selling, right? And so it's hard for me to say in a vacuum, but to me, I think that's one of the things that will come out of all of this too, is how do you value things that don't have an ownership element to it? What are you selling?
And to follow that up, is there anything to the fact that if you can trace all of the IP that was made in the LLM in the first place, like by easily making it a single source IP, does that affect it at all? Because it's still AI created, therefore not ownable. But in terms of rights and in terms of just obeying remuneration and sourcing,
Yeah.
it's technically good, but like, how does it affect the business model?
Yeah, can't say as I know the answer. I think the underlying copyright owners may say to you, I want a piece of whatever it is that you sell, right? You're repurposing and packaging up. So you're, instead of me selling my song as a one-off, you've now combined it into a compilation album and are selling it. So, right. And so I think there's some parallels that you can make, but it also depends on the owner of the copyright. I've always marveled at the people who put their photography up on the Creative Commons for no fee, no attribution. I'm like, good God, then why do you do it? Or the people that I've worked with that are like, oh, I'll just sign this release, and yes, you can use my image in a commercial. I'm like, what? They're like, wouldn't that be cool? And I'm like, oh God, you and I are so different. So it really depends on who, how does the person whose underlying copyright, how do they value it, and what do they want out of their ownership? They may want it everywhere, and the pride of creativity, as opposed to the RIAAs of the world, who are the pride of dollars in the bank. So it really depends. I think it's really interesting, but I can't say that I have a great answer for you.
No, but it sounds like we can at least move to, and it's the last thing, I don't want to take up the whole thing here. Smart contracts and actual immutable contracts that are attached to the media. So it's never in dispute because it's immutable from it. At least that's a way forward in terms of, it may not be for AI necessarily, but for media in general. We don't have to rely on just Creative Commons or saying like, fine, we have to go back to the source of where the hell this came from in the first place. At least we can attach contracts to the media.
Yeah. And I have definitely heard of folks creating these tags, and I liken it to for those of you old enough to remember broadcast flags, where folks didn't like that their content was being their video that they've made, the NBCs of the world, particularly, and I believe NBC started this with the Olympics many, many years ago, of adding a broadcast flag so that if their stuff got pirated, they knew, right? And so the challenge I think some people have is, can that be removed? Can it be pirated differently and blah, blah, blah. But there's, I find that I think any copyright owner that can say, hey, if you can trace my goods through everything, my IP through, great. I love it.
Thank you.
Yeah.
Brooke,
Yeah.
I got a question for you. A situation I've been noticing. I'm based in California, right? I'm not expecting this to. I understand this is just for educational purposes, but as a marketer working with startups, many times you wear many hats and you have to negotiate contracts with influencers, contractors, right? And many times you have very dumb contracts that your leadership downloaded from the internet. But one thing I can expect to see is companies asking, when they're working with content creators, influencers, to get like a irrevocable, non-exclusive license to sublease, or the likeness, the image, the voice, like just they hide it under repurposing the content for socials, but the wording could lead to them being able to sublicense their likeness to create AI avatars, right? So I'm assuming this is probably, from what you said, something that in California would not stand should you get there. And again, also tell me you can answer this, but like, from what you're saying, even if they were like, no, we get your likeness, we can sub-license it to like Getty for them to create an avatar, that would not be legal.
Well, no, it depends on what the contract says, right? So there's a release, right? So when you are, say, on a panel, if you've ever been on a panel and you get the release to be signed, it says that you grant them all right, title, and interest in your likeness, your bio, for use in any means or media now or in the future, right? And it goes on and on. I mean, the paragraphs get longer and longer. And so what a lot of times, as the lawyer for the person receiving that license, or that release rather, I will say, how comfortable do you feel? How much do you want to push back? And do you want to say, you can use it for this, and you can use my image to promote my panel, period, end of story, right? So it runs the gamut. And if I've had celebs do cameos on some of the shows that I've worked on, and the cameo even says, the release says, you cannot use my name or image for anything other than in the show, when the show is in its full. You can't even take clips from the show. You can only show me when the show is aired in its entirety. So it really depends, and you can't, it's only for, cable, or it's only for whatever the medium is. So it runs the gamut.
Okay, so it's important then to add that difference to the contract. It's not like I can say, oops,
That's right.
I signed, but then, I didn't read it. My bad. But
Yep.
Okay, cool. Thank you so much.
Exactly. Yeah, absolutely. Paul, it looked like you were about to ask a question.
Yeah, I have a question about parody. And I'd love your opinion on it for two reasons. One, I used to run a comedy company, and thank God parody was included in fair use, because I can't tell you how many Star Wars sketches we did. But in terms of now, Elon Musk saying deep fakes are parody, it gets much dicier. I just love your perspective on that and what you're seeing out there.
Oh, you're killing me, Paul, because the Copyright Office came out with their first report, which is about digital replicas and deep fakes. And it came out in the last couple of days of July, and I haven't gone through it. So I can't exactly answer, but it depends, right? I don't think, to make a blanket statement that deep fakes are parodies is not factual, right? There is no bright line rule that says a deep fake is a parody. So it really depends on the facts and circumstances. Are they commenting on the underlying work? And if it's a deep fake using a human being, there is no parody rights in your image and likeness. The parody rights are to the underlying copyright, and you've got to comment on that work. So I would say, and frankly, I've got my own opinions about Elon Musk and what comes out of his mouth, but there is no bright line rule on deep fakes and parody.
Thanks.
Yeah, We only have a couple minutes
Yeah.
left. David, I don't know if you if you have any housekeeping, so I can pass it to you, or if anybody has any more questions.
Any last questions for Brooke? I mean, I think we're at a good stop place. What's great is Brooke is part of this community, and again, just like I love nothing more than taking informal back and forth on calls like this and turning this into something where like I learned a ton, and I am seeing a lot of sentiments that echo that in the chat. That I mean, really thoughtful, Brooke, and just grateful to have you as part of this, and I'm sure we'll appreciate informal and formal follow-ups to come. So thank you for being here, and we'll see you next week. We've got the CTO of Huge, and there might be another special guest with him. Terrific agency if you're not familiar with them. Great on things like experience design, and I know their CTO is very deep in AI. And then planning some really fun things for September, including our first APAC event that will be at 12:30 a.m. New York time. So for anyone who knows some folks in more Australia friendly time zones, it's 2:30 p.m. AEST. So to keep looking that one up, but yeah, we're gonna see just all kinds of new things coming, and appreciate you being here and your ideas, and grateful to have all you in the room. So have a great rest of your week, everyone, and hopefully see you next week and in Slack and all that.
Happy summer.
Thank you, Brooke. Thank you, David.
Thanks, everybody.